So we have gone from the accident, the issue, proximate cause. We have our claim. We've had discovery. We've had witness preparation. We have done and we have concluded our depositions. We're at trial now. And so we have three big components of that, which is opening statements, cross examinations, examinations, and then we end on closing statements. Brooklyn, can you walk us through how all that happens?
Sure. So, with regard to opening statement, that is your storytelling time where you are telling the jury what you intend to prove. First, you always want to greet the court in your introduction. You want to introduce yourself and the client. You want to state your purpose, why you're there, because juries don't know what's going on. Like a lot of times it's their first time in court, especially let alone a trial setting. They really are walking them down like a teacher would a student. You state your purpose, like this is what the evidence will show, and then you go down to the overview of your case. You want to briefly explain like the facts to your side. You want to tell the story clear. You want to be logical in an emotionally compelling way. Obviously, your theft of grocery products is going to be a little bit less emotional than, a wrongful death suit, and you do
Uh,
get cases that are hilarious and you're trying theft of thousands of dollars of merchandise and, you know, but you're still trying to invoke some type of seriousness is because this is someone stealing from the community, you know,
$1,000 worth of bananas
that
or crab
people,
legs.
yeah, well, that normally won't see the daylight of trial, but you get the
Oh,
point. And then
yeah.
then you have like the key evidence that you want to highlight, you want to highlight the main evidence or testimony that you intend to produce or show. You want to mention key witnesses that you intend to produce. You want to mention what they're going to say. And keyword will say, will show what we intend to do. You don't want to make any conclusionary statements in your opening because we're opening, we're not closing. We still haven't put on any evidence. And you have to think of trial like an empty box, right? And around that box, you have evidence, you have testimony, you got your jury thoughts, and you have theories. And your job is to get that evidence in the box, get everything in that box that you can. And sometimes you just can't. And based on what's in that box, that is the parameters in which juries are allowed to decide guilt versus innocent. And so it's important to let them know and tip them off on what they're going to see so that when that closing comes, they would have already known what they were looking out for. And it's definitely what you want to establish as far as negligence, since we're on the topic of negligence, you want to establish those elements. If it's assault, you want to establish those elements. What is the elements of negligence, and you have to walk them through that. You've already kind of done that in voir dire, so you're just bringing it in again. So then you have the theme of the case. You want to present central ideas, justice, trust, motive, mistake. What is the theme here? Whatever hat you're wearing. If it's the defense hat, you want to think about accident, mistake, sometimes even motive. If you represent the other side, you want to think about justice, you know. And so, um, the conclusion of your opening then is going to look more about you restating what you're going to show, and then politely asking that jury to keep an open mind and to listen closely because people tune out. Even I tune out, and so they could be missing a very, very nuanced piece that is important. So you want to remind them, hey, I need you to listen and keep an open mind.
Mm,
Um, Especially if there's going to be some bad facts
mm,
that might not paint your client in the best light. You want to just kind of get that out in a way that doesn't, you're not saying your client is guilty, but you're saying he's human, he or she. Hey, you're going to hear some things. You might hear this, you might hear that, but I need you to understand that this is a trial process. A lot of evidence needs to be had, so just keep an open mind as we continue on. And then after that opening statement, the other side will have the opportunity to provide their opening statement, and then you have the direct questioning, which is where you're putting on your case in chief and you're directing your client to the answers and testimonies that's going to support his or her case. This is not a cross-examining. You're not being hostile, even though in certain cases you put on your own witness and you have to treat them hostile.
Why
Which
is that?
that is another story. But it's sometimes you have to put on a witness that flips on the stand and says things that what did not anticipate on saying, and now you have to cross-examine them in order for them to bring out to tell the truth of what you put them on there for.